Alright, karibu sana, habari za mchana, mabibi na mabwana. A very warm welcome to everyone joining us today. My name is Gabriel Achaye, and I'm deeply honored to moderate this very critical conversation that is hosted by the East Africa Law Society in partnership with Afya na Haki, an organization that is at the forefront of advancing health and justice across Eastern Africa. Today, the 3rd of April 2025, we are diving into a pressing yet very timely topic on the impact of the US foreign policy on reproductive justice litigation opportunities for lawyers. So, as a human rights advocate with over a decade of experience in human rights advocacy across the region and across the continent, I have witnessed firsthand how the intersection of law, policy, and justice shapes the lives of millions of citizens within the continent. From the bustling streets of Kampala to the courtrooms of the ESG, I've seen restrictive policies like the US global gag rule ripple across borders, threatening reproductive autonomy and health access in ways that demand bold, innovative legal responses. Today, ladies and gentlemen, I bring that lens to this webinar session where we'll unpack these challenges and spotlight litigation as a transformative tool for change. But before we delve into this discussion, let us set the stage. Since 1984, the Mexico City policy, often called the global gag rule, has been a political pendulum swung by US administrations, cutting funding to organizations that provide even discuss for abortion services. In East Africa, nations like Uganda, Kenya, Tanzania, Malawi rely heavily on foreign aid. These restrictions do not just limit healthcare, but they entrench inequalities, they criminalize reproductive choices, and silence minority voices. But there is a silver lining, and that's where there is a challenge and an opportunity. In this webinar session, we shall be equipping you, our participants, with the tools that fight back through strategic litigation, regional alliances, and unyielding advocacy. Now, ladies and gentlemen, I'm profoundly honored and exceedingly humbled to introduce my extraordinary panelists, three legal luminaries whose expertise spans judicial benches, human rights commission, and academic halls. Their work has reshaped justice across the region, and today they'll be here to share their insights with them. Briefly, let's meet them, ladies and gentlemen. My first panelist is Ms. Rizik Nambuya, a judicial officer at the Judiciary of Uganda and a lecturer at the Islamic University of Uganda with over 12 years of legal experience. Rizik is a powerhouse in adjudication, litigation, and legal education. On the bench, she's presided over complex civil and criminal matters, delivering timely, reasoned judgments while mentoring judicial staff. In the classroom, she has shaped minds with courses like criminal law and international humanitarian law. Her career spans from being a managing associate at Mutembuli and Company Advocates, a legal officer for the China State Construction, where she tackled disputes from land to labor rights. A global voice, she's represented Uganda at different forums like the All Africa Course on International Humanitarian Law in Pretoria, South Africa, and she also holds a Master of Laws and a Bachelor of Laws first class diploma in law, all from the Islamic University of Uganda, plus a postgraduate diploma in legal practice. Welcome, Rizik. You can turn your video on and our participants get to see.
Hai, Assalamualaikum.
Walaikum salam. It's good to have you on board.
You're welcome.
My next panelist is a lady who is so special and profound, Miss Chikondi Chijozi, the chairperson of the Malawi Human Rights Commission in its eighth cohort and a member of its seventh cohort. Chikondi is a passionate human rights lawyer with over 11 years of practice, currently heading the criminal justice program at the Southern Africa Litigation Center, SALAC. She's an expert on the Committee for Prevention of Torture in Africa under the African Commission, and her litigation record is nothing short of inspiring. Think decriminalizing rangacy offenses, securing education rights for Rastafarian children, and protecting sex workers, prisoners, women, and children. Before Slack, she was the Deputy Executive Director at the Center for Human Rights Education, Advice and Assistance. Chikondi holds a Master of Laws in International Human Rights Law from the University of Sussex and a Bachelor of Laws Honours from Chancellor College University, Malawi. Chikondi, we are so glad you are here. You can unmute, turn your camera on, and say hi to our participants.
Hi, everyone. Thank you for having me, Gabriel.
Pleasure is all ours. Then finally, we have a man who is a luminary in the region, Dr. Tom Mulisa, the Executive Director of the Great Lakes Initiative for Human Rights and Development, GLEAD, and a lecturer of the Faculty of Law, Uppsala University, teaching comparative constitutional law for Africa. Mr. Mulisa's academic journey is remarkable. He's taught international human rights law, constitutional law, and sociology law at the University of Rwanda. He has served as an external examiner at the University of Pretoria's Center for Human Rights and has trained at institutions like the University of KwaZulu-Natal on intellectual property and access to medicines. A practicing advocate of Rwanda's High Court and a member of the East Africa Law Society, Dr. Tom has founded GLEAD to drive advocacy, strategic litigation, and accountability in the Great Lakes region. His current research on supranational constitutions takes him to courts like East African Court of Justice and the Court of Justice of European Union. Dr. Tom, it's an honor to have you with us. You can say hi to our participants.
Hi to everyone, and thank you very much for having us. Thank you.
Thank you, Dr. Tom. Now let us dive into the discussion of the day. And in this great lineup, we will be asking our panelists questions and they will be answering. But while we wait for them to answer, you can just drop a clapping emoji in the chat room to welcome our panelists and make them feel at home. I will start with you, Dr. Tom, since you're with me here in the Great Lakes region. So, Dr. Tom, in the Great Lakes region, you have countries like Rwanda, DRC, that I know you have worked closely with, and you have these countries have unique ties to foreign aid in terms of relying on foreign aid for a number of of issues to be handled by those countries. So, my question to you, Dr. Tom, as we start our fascinating conversation, is how do policies like the Mexican City policy, or call it the gag rule, exacerbate inequalities in reproductive health care, and what role can international human rights law play?
Yes, thank you very much, Gabriel. I hope you can hear me.
Can you hear Dr. me? Tom, clear.
Yes, yes. I think the gag rule is not new for this year with the recent changes within the U.S. administration. I think even previously, the region had already faced the impacts that the gag rule had put in place. And I think the region is feeling the impacts of the gag rule right now because this affects funding. As you said, it exacerbates the inequalities. Already there have been existing inequalities within the healthcare program. And far most, it affects the funding on most healthcare initiatives, especially maternal health programs. And I think most maternal health programs, especially post-abortion care, which had been given a priority, have been affected by this gag rule because for most funding organizations who contribute to the reduction of maternal mortality and infant maternal mortality have been affected by this rule. And I think the question on what role can international human rights law play with this, I think which is central to the discussion today, is that we should be able to utilize the existing platforms. Like here in Rwanda, we've used courts to challenge some of the provisions that are not in line with the African Women's Protocol. That's the Maputo Protocol, especially Article 14, for countries that have no reservation, like Rwanda. So you can always use regional. We've been to the CEDAW committee last year. We met the committee on the Convention on Elimination Against Discrimination, and we got recommendations that were given to our respective countries, especially Rwanda, and we have also used the African Women's Protocol in Banjul at the African Commission. We use such forums to use the international and regional frameworks to challenge legislation, especially internal legislation that may be against the rights of women, especially when we are talking about access to reproductive healthcare services, and when you're talking about the right to access to safe abortion. So I think we already have the impact right now. Funding has gone down, and healthcare priorities like maternal health that have been contributing, most organizations cannot do that. And I think this creates more inequalities and inequities that have been existing. And as said, international human rights law could play a significant role by using the treaty bodies, by using regional and sub-regional courts, but also by using our own regional and international legal frameworks that we have in place. Thank you. Thank you, Gabriel. Gabriel, I can't hear you. I don't know whether others are hearing you. I can't hear you.
Okay, thank you, Dr. Tom. I was muted, but I was saying those are quite fascinating insights. And given the fact that you have brought in the conversation and say that we can explore both treaty bodies, regional and sub-regional courts to advocate or rather combat this gag rule. I would like to bring the conversation in to Rizik, who is a judicial officer in Uganda. And I'm sure in your practice, Rizik, you have seen how these US policies coincide with stringent national laws on abortion. So as a judicial officer, how have you seen them influence judicial outcomes or healthcare access? And what challenges do they pose for enforcing reproductive health in Uganda's legal system?
Oh, thank you very much, Gabriel. Can you hear me?
Yes, Your Honor, I can hear you.
Well, I will draw your attention and that of the listeners to the case I tried on recently on attempts to procure abortion. That the accused was tried under Section 130 of the Penal Code Act on simply procuring to abortion. Well, I look at this scenario that yes, I found her guilty, and under the law, I had to read exactly on what is the most reliable punishment to give to her. But I feel that this has simply been coached for us to have it here, because the US insists that they cannot have this under the law. And even when it coincides with ours, you realize that it could not be, I could not look at the circumstances that caused this lady to have to procure abortion for the person whom she was helping. Maybe it was out of incest, or it was out of defilement, or it was out of, you know, rape. But because we coincide, our national laws that are very restrictive coincide with the global gag rule, which is equally restrictive, it ends up victimizing such. Maybe they needed more help than a conviction that I issued. That's how I look at it. And well, it poses a big challenge, because when our communities are faced with a challenge, we would rather address on a challenge rather than adding up, sanctioning the issue instead of availing them with a solution. I hope I make it very clear, Gabriel.
Yes, Your Honor, and thank you for those very wonderful insights. Let me now bring in Chikondi, who sits at the Human Rights Commission in Malawi. Chikondi, from the discussion from our panelists, it seems very clear now that the global gag rule has disrupted funding for reproductive health in countries like Malawi, Uganda, and others, which heavily rely on this aid. From your work at the Malawi Human Rights Commission and SLAC, how have these policies tangibly affected women's reproductive autonomy, and what legal gaps do they expose for lawyers in East Africa to target?
Thank you so much, Gabriel, for the question. I think are you able to hear?
Yes, Chikondi, we can hear you.
Yes, Chikondi, we can hear you. Yes, Chikondi, we can hear you. Yes, Chikondi, we can hear you. Yes, Chikondi, we can hear you.
Okay. So what I was saying is that maybe to start with, we also need to recognize that the global gag group does not stop as states, independent sovereign states, to implement reproductive health rights, reproductive justice. The only thing that it does is to restrict funding for promoting abortion and other reproductive services for countries that for NGOs and countries that use the US fund in their activities for reproductive health. So in our own jurisdiction as countries, with the Maputo Protocol, which clearly provides for reproductive health rights, as countries, we should have the autonomy to say, in our country, we recognize rights of women, reproductive health rights of women, which in some countries are even provided for under the Constitution. In some countries, they even enabling legislation that has provided for reproductive health rights. So there is no reason why within our continent, where we have the Maputo Protocol, which expressly provides for reproductive health rights, although with some level of restriction, but also within our laws in our jurisdictions, we do have laws why we should fail as countries to implement reproductive justice. And I think it's a problem that we have as a continent, where so much of rights, especially economic, social rights, in terms of their implementation, we've not put them on the agenda at the national level, so much that what the US says becomes our agenda, which is very unfortunate, because the women that are dying in our countries are not dying in the US, they are dying in our country. And today I was looking at the papers in Malawi, in just 7 clinics in one locality in Malawi. They were comparing the statistics from 2023, where they registered cases of complications resulting from abortion were 173 cases. And in the same clinics this year, they have registered 1,200 something, which tells you that this is a problem for Malawi. And even in those countries that are having those challenges, it's a problem for those jurisdictions. It's not a problem for the UN. So we cannot be saying we are failing to provide services for our women, our girls, because there's a global gag. We need to come to a point as our countries do budgeting for this, because these are rights. These are things that are not privileges. They're rights that we have recognized as a continent under the but also within our constitution and also within our enabling legislation. So I just wanted to set that as a tone to say that let's not allow the global gag group to determine how we protect our women, because the issue more there is about funding. And I know there's so many countries that rely on the US funding, so many NGOs, and answering your question, yes, it has affected because so many NGOs that have been receiving the US fund have been forced to align their program to to the global gag group, to the extent that the services that they were offering to women have been they have been forced to curtail them because they had to align themselves to the policy in the UN. But at the same time, how are we working towards institutions within the country to mitigate the global gag? Now, answering in terms of the Malawi Human Rights Commission, as a commission, we've taken the stand that we are a human rights commission. We're supposed to protect rights for everyone, including the reproductive health rights. And to even make it worse for us at the Malawi Human Rights Commission, the Gender Equality Act recognizes reproductive health rights, and it gives the Malawi Human Rights Commission the mandate to ensure implementation of the act itself. And there is actually a case where the Malawi Human Rights Commission has been sued for failure to ensure that a girl who was raped had access to abortion services. And the case is still in court. So for us as a commission, we know our mandate is to make sure that every woman who needs these services are provided because it's provided by law. So whether there's a global gag group or not, but within jurisdiction, we are mandated to do that. And when I speak about the work that we've done under the Southern Africa Litigation Center, we've supported cases which I might speak about later in terms of access to reproductive health rights for women in Zambia. We've done a case in Lesotho. We've done a case in Zimbabwe. So some of those are examples of interventions that we've done in the existing restrictive circumstances that we're working within under the global. Thank you so much.
Thank you so much, Chikondi, for those insights. Indeed, it's true. I couldn't agree with you more that with or without the global gag rule, rights are rights, and they ought to be protected and not hide behind foreign policies to stifle on human rights. That said, as we go into the next segment of our discussion, I have received a comment here from my good friend, Mr. Bonnie Obara, who has requested to see you, our esteemed speakers. So I'm going to request you now to turn your cameras on for this next round, such that people can see your faces and know that it's not robots that are talking. So we'll now shift our discussion to what's working. We've looked at the global gag rule, and we've looked at the different panelists' discussions on the effect that this global gag rule has had. But now we want to shift to what's working. And in this segment, we're going to look at successful litigation models. And I will start with you, Rizik, who is a judicial officer. Uganda has seen cases tackling maternal health care failures. Can you share a specific example, either from your experience or from within the region, on how litigation can counteract US funding restrictions, and what lessons can lawyers draw from these? Rizik?
Gabriel, can you hear me?
Yes, I can hear you. Thank you.
Well, thank you very much, Gabriel. In Uganda, like Chikondi is saying, we have local solutions to our local problems. We did not wait for the US funding to come and save us on this. As early as 2021, there was an organization that is responsible for the health of the maternal health or reproductive health in Uganda that was joined with a professor called Professor Bentwino Mugisha and Madame Rhoda Kukiriza and Inzuku Valete. They decided to take the government of Uganda to the courts of law, and they sued the Attorney General on obvious things. One being omissions by the government for not providing the minimum standards or the minimum maternal health services. And it led to deaths of several mothers, armed with several affidavits about the relatives of the deceased persons. They went to the Constitutional Court to have these provisions that have been highly highlighted under our constitution, and to see if the government is not violating what is supposed to protect. Well, the good news is the government of Uganda, the Constitutional Court found that the government is actually violated its own provisions of the mother law, which is the grand norm of the country, the constitution, and as such, they declared the provisions as null for the fact that they declared that the acts of the government was contravened the provisions of the constitution, rather, and they made certain recommendations for the government to catch up and make sure that we protect or preserve the right to health. The other case that I would interest the listeners to is the case of the executive director of Mulago National Referral Hospital versus the Attorney General. This was a case that was decided in 2013. In this case, Lady Justice Lydia Mugabe, after listening to the incidents of what happened, maybe briefly, was that these were parents who were expecting twins, and while they were discharged, they were only given one twin baby, and the hospital told them the other twin had passed on. And after several days of asking for, okay, give us the dead body, they could not even produce the dead body for the other twin. And this prompted them to institute a case against the hospital. Well, in this incident, Justice Lydia Mugabe found that really it caused a lot of psychological torture, violating the rights of the applicants of free from cruel or inhuman treatment, and also the right to life. But most interestingly, she made a structural interdict. She felt like declaring that, yes, the rights of these people have been violated is not sufficient as court. So she instead went further and made a structural interdict, instructing the police to carry out an investigation to see the disappearance of the baby and to file a report within a given time, which was specified 6 months from the date of the judgment. She also instructed that the midwife who handled the baby at that time of birth would be held accountable on the movement of the baby from her care. And she also instructed the executive director of Mulago Hospital to furnish reports every after 4 months to have the court enlightened on which steps that have been taken on to provide for safety of the babies at the hospital, and for general improvement on right to life and health services. And I wish to tell you, Gabriel and my colleagues, that it has, from the time of 2013, the courts have registered a positive outcome. There have been low rates of registered disappearances of babies at Mulago Hospital, and the health services have greatly improved. So we find that the courts have actually demonstrated, away from the obvious waiting for funding, like Madam Chikodi said, we have local solutions to our local problems. When we look away from the funding, we can find our own solutions here, and in that way, we uphold the right to health. Thank you very much, Gabriel.
Thank you, Rizik, for sharing those very interesting cases and how Ugandan courts are now, looking for local solutions to local problems. I just want you, before I move on to Chikondi, I just want you to highlight some few lessons that lawyers can draw from these cases when it comes to matters of litigation of this nature. What lessons can lawyers draw? Your Honor, can you hear me? Your Honor, I think you're muted. Thank you.
Oh, well, sorry. Yeah, sorry about that. I was saying the fastest or the most direct lesson that the lawyers can draw from this is that, one, they need to see that their advocacy yields. It bears yield to whatever they want to advocate for. The courts are there listening and actually providing remedies that are providing solutions to the communities. And also, they can learn that there are opportunities of advocating for the vulnerable groups. And as such, the lawyers can learn to actually find such vulnerable groups and try to provide some remedies in form of representation for them. And the third one, the lawyers can draw from these cases, is that they can have a way of interacting between the US lawyers or legal representation and us over the normal policies that are accepted or that are provided for from both constitutions, both in the US and both in Uganda. So they can have their platform stretched away from the local to the international level. Thank you very much.
Thank you, Your Honor, for those wonderful insights. Let's now broaden this discussion and bring in Chikondi. Chikondi, I know for a fact, under the Malawi Human Rights Commission, you have led landmark cases in Malawi on women's and children's rights. And my question to you in particular is, can you highlight a strategic litigation success that challenged reproductive justice barriers and how it may inspire efforts against policies like the global gag rule?
Thank you so much for that question. I think I'll comment more not the Human Rights Commission in terms of Southern Africa Litigation Center, where I had the criminal justice program done in terms of strategic litigation in regard to reproductive health rights. So the first case that I will draw your attention to is the case that I was referring to earlier on from Lesotho, where SALC supported some women who were working in the defense force in Lesotho, who were discharged of their duties because they had fallen pregnant. So the policy of the defense force was that a soldier or an officer of the army who was a new recruit and had not served more than 5 years of service could not fall pregnant. So these 5 women had fallen pregnant, and because of that, they were discharged of their duties, and then they challenged the decision of the army to dismiss them. And when the issue came before the court looked at the international human rights framework in regard to reproductive health rights. The court also considered the Maputo Protocol as well, and found that the policy by the Defense Force was discriminatory against the women because they had a policy which allowed for maternity leave for women working in the army, but only that applied to those that had served more than 5 years in the army, which the court thought that it was discriminatory to those that had served under 5 years. And also looking at the fact that women still, when you talk about reproductive health and reproductive justice, is that women retain their autonomy to choose when they can have children and when they cannot. And also, there was an assumption in that policy that women who are pregnant cannot do certain things. They are incapacitated by their pregnancy, and they do not recognize that pregnancy is a condition that is only for a period of time. It's not a permanent state that would warrant someone to be dismissed out of their employment. So the court considered that it was an irrational decision that was made by the army to discharge them of their duty. Also considering that their own enabling legislation do not provide for a pregnancy as a basis on which someone could be dismissed or discharged of their duties. So that is one of our biggest successes. Sorry for that. So we have seen in terms of courts actually applying the principles of human rights as pertaining to reproductive health rights. Of course, we should understand that these kind of successes, they do differ in different jurisdictions. There are other courts in other jurisdictions that take a very restrictive approach and do not apply these as principles as they were. Even though they are provided within the law, you find that in some courts, the court will use restrictive rules of procedure to not allow women to access reproductive health rights. Thank you.
Thank you so much, Chikondi. Those are quite interesting insights that you've shared, and quite interesting cases that I know many of our practitioners can leverage from. And so I want to move to Dr. Tom. And Dr. Tom, I want us to widen the lens a little bit. We've shared what has worked in Malawi. We've shared what has worked in Uganda. We've seen the judgments of these different courts on reproductive health rights. And I want to draw on your advocacy at GLID, because I know you have done a lot of work around this area. How can lawyers in the Great Lakes region use frameworks like the Maputo Protocol to challenge criminalization of reproductive health decisions that are tied to these US policies? Dr. Tom?
Yes, thank you very much. I think, first of all, we've used the protocol itself here in Rwanda to challenge the provisions of the penal code. Previously in Rwanda, to access abortion, one needed a court order. You needed to go to court and prove that there was incest, or prove that there was a forced marriage, or prove that you've been raped. So the only ground for accessing abortion was the health of the mother or the child. All the other grounds, you needed a court order. So we took a case to the High Court of Rwanda, I think I appeared in the court on behalf of our organization, and the case was a 14-year-old who had been defiled. So we took the case to challenge the condition that one does not need a court order. So from the decision of the court, we used the Maputo Protocol. It's a judgment that could be shared. We've got it translated to English, and the court stated that Rwanda is a signatory to the Maputo Protocol. Rwanda has no reservation on Article 14 of the protocol, which provides the conditions for abortion. So being a signatory to the Maputo Protocol and having no reservation on Article 14, domestic laws should be compliant with the regional tools and organization. So the court stripped away the condition to have a court order. And it's the very decision of the court that we submitted to Parliament while the penal code was being reviewed and the court order was removed. That is the litigation and using Maputo Protocol as a standard in court. It was the first judgment in Rwanda that Maputo Protocol has been cited in the judgment and interpreting the role of international human rights instruments within the national legal system. That was one case. The second case that we had 2 years ago was taken by GLID, and we had amicus from the Center for Reproductive Rights. I think for those who do reproductive justice litigation, know CRR, they have done quite a number of litigation around reproductive justice. So we were challenging a provision. We're challenging a provision in the penal code, still that and the ministerial order on abortion that suggests that abortion can only be done at a district hospital, not a health center, which is the nearest to the population. And again, that abortion could only be done by a medical doctor, not a trained medical health professional, because we knew we had few doctors and we didn't have doctors at health centers. So we took those conditions to court and stated that these conditions defeat the purpose of Article 14 on issue to do with access to reproductive health rights. And I think the court decision, when you're doing litigation, the court decision tells us that this is going to be a progressive right, that in case resources are in place, then the state would be able to avail doctors at a health center and would also be able to have trained mid-level professionals. But I think after the court decision, we've had last year a change, and the government has allowed now that access to safe abortion could be offered at health centers. That is 1 year after the case. So I think that the other question you talked about, the regional, what CSOs could do at the regional level, I think not only using courts, but not only using courts and constitutional challenges, I think regional CSOs should work together. Let's say have a regional petition, a petition to the East African Court of Justice. They should work together, joint shadow reporting, like the upcoming session in May in Banjul at the African Commission. Why not a regional network, let's say Solidarity for African Women Rights, or any other network that is existing, FEMNET, and why not have a regional petition or a regional communication or a regional shadow report with CSOs working on a similar perspective, let's say before the SADC, before the East African Court of Justice, or before the African Commission. So I think that regional CSOs could work together, do a joint shadow report. I know some CSOs in Rwanda that are working with CSOs in Uganda, especially SIHA, and CSOs in Kenya, to have a joint submission to the African Commission. I've seen CSOs in the region working together to have a regional submission at the CEDAW committee. So I think regional submissions, let it be a regional case, let it be a regional shadow report, could also assist in networking, but also creating a better voice in terms of advocacy. Thank you, Gabriel.
Well, thank you so much, Dr. Tom. I love the ideas. I love the diversity of approaches here. You have indeed highlighted CSOs coming together, working together, doing shadow reporting, regional submissions and cases. And I really love the diversity and the perspective, Dr. Tom, that you bring into this discussion. Just before I shift to the next segment, Dr. Tom, I would like to ask you, is there anything from the submissions of Chikondi and Rizik that resonate with your work, so that we connect these dots? Because from their submissions, they've shared how their different jurisdictions have handled strategic litigation in this area. So does anything from their submissions resonate deeply with your work as we move to the next segment?
Yes, thank you very much. I think I've always been in touch with CSOs in Uganda and Malawi, and my organization and myself participated in quite a number of workshops in the maternal health case petition in Uganda with SEHUD, because SEHUD is our partner here in Rwanda. We've learned a lot with working together with SEHUD, because they've had constructive litigation processes, and it's the very lessons that we've taken to do the same litigation here in Rwanda, having SEHUD in Uganda and having KELI in Kenya. So this whole network of organizations that use litigation as a strategy has been working for us. So what the judge was talking about, I understood it very well, because we attended most of the strategic meetings on the case of petition 11 and on the maternal mortality case, and I think this helped us in Rwanda, because when in the first judgment, when the judge raised the political question issue within that case, as if to say that issues to do with health budgeting should be left to the politicians and government, it made us to avoid that route when we took the case in the Supreme Court of Rwanda to seek that services be provided at the health centers, which are very near to the people. So I think it's quite good that when you understand the context in one country, you need to understand the context in your own countries. And I think attending meetings, we've been with colleagues in Malawi that are working around sexual reproductive health rights. We've worked with most of them, even the IPAS group in Malawi, and we've worked with most of them at the African Commission, and there's some other levels and levels. So I think what they were all saying is important, and what I picked out is there's need to understand even the local context. Understand the local context. What do you need to pick when you are doing advocacy locally? What do you need to pick from Malawi? What do you need to pick from Tanzania? What do you need to pick from Kenya? How do strategies in Uganda work? How do they work? So you need to understand your own system and dynamics, and see the challenges that your colleagues had over there in order to be able to apply some strategies in your own context. But I understood very well what they were saying, and it's quite important that you have someone from the court and someone also. It's quite important that our human rights commissions take this champion such issues of sexual reproductive health rights. Thank you.
Thank you, Dr. Tom. Ladies and gentlemen, it is 3 p.m. On my time. And if you're just joining us, you're welcome. You've already missed almost half the segment. And the discussion today is the impact of U.S. foreign policy on reproductive justice, litigation, opportunities for lawyers. And that was Dr. Tom Mulisa that you just had speak there, the executive director of the Great Lakes Initiative for Human Rights and Development. We have two other panelists, Ms. Chikondi Chijozi, the chairperson of the Malawi Human Rights Commission, and Her Worship, Ms. Rizik Nambuya, the magistrate, grade one, at the judiciary of Uganda, at the Republic of Uganda. Ladies and gentlemen, if you're just joining us, my name is Gabriel Achaye, and you can drop those questions in our Q&A segment or in the chat room. We'll be able to answer them. We are also streaming live on YouTube. So tell your friend, tell a friend to join this session while it still lasts. Now we are moving on to the next segment, and it's now time to get practical. We've had about the global gag rule and its effects. We've seen what works in terms of strategic litigation, shared what lawyers can learn, what civil society organizations can learn in advancing sexual reproductive health rights. And now we are going to actionable strategies. And as we get practical, again, I'll stick with you, Dr. Tom. You've worked across borders in the Great Lakes, and I would like to ask you what collaborative strategies, like the proposed Africa Reproductive Justice Litigation Alliance, do you see as the most effective for lawyers to challenge US policy restrictions and ensure sustainable outcomes?
Yes, thank you very much. I think it's an opportunity that at least I've been privy to understand the Africa Reproductive Justice Strategy. I usually say that I'm a student of Afya na Haki, because when you're talking about litigation and reproductive justice in Africa, well, I think most of us are learning much from Afya na Haki with regard to how to take litigation as a strategy and a tool. So I think working together is quite important, because I've already seen a group of CSOs under the umbrella of the Solidarity for African Women, SOAS, taking a regional action. Such an issue shouldn't be taken by individual CSOs. CSOs can always come together, the CSOs in the region, and challenge a policy or challenge legislation at the regional level. We've had CSOs taking petitions at the Supreme Court of Justice on other issues related to health and HIV. Why not also CSOs coming together in the region and take up an issue jointly with regard to reproductive health and the limitations in laws and policy? So what we have always been arguing is that it's quite important to build a regional network. It might be a loose network, but that's quite important to have a regional network so that you all put evidence together and then be able to submit a regional cause at a regional court or a regional forum that may be in place. So what is important? Number one, putting in place such a network. It's quite important. The network of organizations working around women's rights. You put together Taula in Tanzania and others, bring together other organizations. We have the team of organizations in Uganda coming together, and then putting together a collaborative actions. I think that would be the best way to go with the issue of forging a regional network that would be able to use both national and regional frameworks. Thank you.
Amazing, amazing, amazing. Thank you, Dr. Tom. Those are quite wonderful insights. Now I'm going to shift this conversation to you, Chikondi, in Malawi. Grassroots groups often lack resources to take on these legal fights. I think this problem is synonymous not only to Malawi, but I could say the entire African continent. How can the Malawi Human Rights Commission partner with lawyers to bridge that gap and amplify marginalized voices in reproductive justice litigation?
Thank you so much, Gabriel, for that important question. And I think it's important because most of the times, as maybe human rights activists or institutions that promote human rights, we put ourselves forward when it comes to advocating for rights for vulnerable groups, and we end up forgetting the community voice, which is quite a very powerful tool when we want to bring change. Because most of the times when we advocate for rights for marginalized groups, and especially those that um, discriminated or their issues become very controversial, especially when we talk about issues of abortion. There are things that become very controversial, and where we have just activists going forward or institutions going forward without the grassroots, without the communities that are affected, it becomes challenging because then that voice is left behind. People start looking at the issues more like you are focusing on certain influences, whether it's Western influence or maybe you are focusing because you have funding that allows you to do such activities. But then when we bring in the community, we or the grassroots, we are showing that this is an issue that affects an individual. A human being is behind that. So as the Human Rights Commission, we've worked with different stakeholders, different communities on various issues. I was earlier on talking about the mandate that we have under the Gender Equality Act as the Malawi Human Rights Commission to implement the Gender Equality Act itself in its entirety, but in particular also looking at issues of reproductive health rights. And what we've done is to engage with the communities extensively to raise awareness of the act itself, what what rights are provided within legislation, so that the communities are empowered to know that if you go to a clinic and ask for abortion services or reproductive health rights, whether it's contraceptives, if they are not there, that is a violation of your right as a woman in terms of access to services. So we've done nationwide kind of awareness in different parts of the country, and also engage different stakeholders who are the service providers, to those that also exclude certain groups of people, or those that deny services because of their other beliefs, whether it could be religious beliefs or just personal convictions on certain other issues. So I think as a commission, we stand on a privileged point because we do this within the mandate that we have under legislation. So we are bound to ensure that people do have access to services. But also the other aspect of it is to make sure that people are fully empowered, they're aware and fully empowered to be able to demand. Because in many cases, we might say these are rights that are provided for, but in many cases, people don't even know that those rights exist. So it's important that people know so that they're able to demand those rights, but also know where they do have challenges. So recently, together with the Office of the Ombudsman, we put together a description of the mandate of this institution so that people can understand that if I'm facing these challenges, these are the institutions that I can go to, this is their mandate, and these are the rights that I have. And if these rights are violated, what are the remedies that are provided under the law? Thank you, Gabriel.
Thank you for those wonderful insights, Chikonde. Indeed, those are quite practical and actionable. And as we move now to you, Rizik, as a judicial officer and an academician, I would like to ask you on the practical steps that East African lawyers can take to leverage on regional mechanisms like the East African Court of Justice, the African Court on Human and People's Rights, or national constitutions to hold governments and donors accountable for reproductive rights. I listened in carefully when Dr. Tom was submitting, and he shared that when he was litigating one of the cases in Rwanda, uh, the, the question almost turned into a political question, and that's something that the judiciary always runs to. So, as a judicial officer and academician, how can we, as East African lawyers, leverage on these mechanisms to hold government and donors accountable?
Uh, well, thank you very much, Gabriel. Actually, the political question was raised in the Sehad case when Professor Sehad and Professor Ben Trinomgisha took the Attorney General to court. The first issue that court landed on was like, no, this is a political question, but the Supreme Court overturned the decision and they ordered for a rehearing of the same, and they found the government in contravention of the provisions of the Constitution. Well, that is a lot we can actually do, or we can actually advise the legal practitioners to embark on. For instance, bearing in mind that the Constitution of the Republic of Uganda actually provides under Article 22.2 that one has no right to terminate the life of an unborn child, but it provides for exceptions, except when authorized by law. So I would challenge the legal practitioners to creatively use the exceptions and widen the scope of when actually, if an abortion is warranted, it can be done under the law. And that way, we can find room to challenge the global gang policy, which also, after analyzing it, actually, it does allow abortion to be carried out in the first trimester. So if the legal practitioners, the lawyers in Uganda, can run from the High Court to the Constitutional Court and to the regional courts, they can actually find a way of challenging the criminalization of these provisions and instead widen the scope of the exceptions that are provided. We have all been talking about them. I remember Dr. Tom mentioning the elements of incest and rape or defilement. I mean, the right to health is broad. It includes also your mental health. So if someone has been actually raped or defiled, or it is an act of incest, we wouldn't subject such person to go through all the way into having this baby and maybe shattering her future, when we can actually provide a practical solution and save the world. So I would challenge the practitioners to creatively use the exceptions to widen the scope. And that way, we can also find a solution to the global gang policy. Secondly, there are other movements. For instance, what still Dr. Tom was mentioning about the same case of Sehad in 2011, where they had to move to court to have the acts of the government faulted. Like there has to be a watching dog somewhere, making sure that the rights of these individuals are not violated. And the people who can move court as the legal practitioners, I would still challenge them to embark on that and find solutions for the society. I hope that is okay with you, Gabriel.
Yeah,
we would like to
Thank
expand
you.
on
Thank
something.
you. Thank you, Your Honor. You have answered the actual foundation of my question, but still with you, we've heard from Ms. Chikondi on her grassroots focus, and I'm wondering, does this grassroots focus spark any thoughts from the judicial side?
Y- Yes, sure, it does. It does. As courts of judicature, we hold a noble role to actually um, change the society. We have that power to change the society. So right from the grassroots, if the right petitions are filed in the right courts, and we are the right judicial officers advocating over these matters, right from there, we can say that there are better solutions that can be forged out in upholding the right to health. And of course, it comes with different exposure to different forums like this. That, for instance, I have, since I embarked on the research about reproductive justice, I have become a better judge, a better magistrate in this field. And I think the other case I told you from the beginning of my discussion about procuring abortion, if I had been enlightened like I'm enlightened now, maybe the decision wouldn't have been that much. It would have been a little improved. So, like from the grassroots, we need to change ourselves first before we can move forward to the other.
All right, thank you, Your Honor. Ladies and gentlemen, you are still logged on to this very wonderful discussion on the impact of U.S. uh, foreign aid cuts on reproductive health. And this session is hosted by the East Africa Law Society in collaboration with Afya na Haki. Now we are moving on to the next segment that will be our general segment where I will pose questions to my panelists and will answer them uh, in a sequence. But before we go there, if you have any questions, any comments, I encourage you to drop them in the chat room or post them in the queue and a segment, and we'll be happy to answer them. So as we move forward now, I would like to uh, 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 open it up to you, my panelists, and I'll start with you, Tom, then Chikondi, and then Hawaship Rizik. And my question to the three of you is: litigation oftentimes is referred to as a tool to dismantle barriers. So my question is, what is the most pressing legal mechanism, national, regional, or international, for East African lawyers to challenge US policy ripple effects? And how can we collaborate effectively? So I'll start with you, Dr. Tom, then Chikondi, and Your Honor.
Yes, thank you very much. It's a hard question of asking what is the most effective legal mechanism, because I don't see any advocacy effort that one can pursue alone, because I think that litigation should always be taken together with other strategies. I don't see it as an only standalone, because you can't pursue litigation even without having the people involved in litigation. Those are advocates, those are judges, those are registrars. Without having them even get trainings and information around international human rights instruments on how they apply, and having them also understand the right to health. So before taking on even litigation, you need to have such engagements like training, webinars, sessions with those involved in litigation. That's one. Number two, you can't succeed in litigation without data and evidence. I've always told lawyers, even the previous meeting with lawyers organized by the South African Law Society, I think, with the center in Dar es Salaam, I think what I said was that evidence is quite important, even for judges, because if you're talking about a gag rule and you are talking about a policy or a law that has a negative effect, the judges would like to get that evidence that you have done. So research is quite important even when you are doing public interest litigation, because if you can bring data of women and young girls who have died or those who have been affected by this, whether government policy maker or legislator or judge would be very happy that you produce scientific and credible evidence of what you are talking about. So I always say that research, engaging through trainings with those involved in litigation, identifying them, and so that you have you're on the same level of information on understanding the right to health with them. And then another thing is joint submissions, because we've had joint submissions. We have had joint submissions and making an alliance. I agree very much with Afya na Haki on the issue of creating a justice litigation alliance so that we benefit. Some of our countries that have not taken long with public interest litigation and strategic litigation yeah. So that we listen and study from other jurisdictions. Thank you.
Thank you, Dr. Tom. Let's move to Chikondi, then Hawaship.
Thank you so much, Gabriel. In answering that question, I think it's really a complex question because it all depends on the circumstances and what is effective in that particular situation. Because every case will be dealt with on its circumstances, and I think developing jurisprudence within our jurisdictions should be something that we should aim for, because we have seen that most of our courts, especially particularly in Malawi, they are very slow at adopting what has been adjudicated elsewhere as opposed to what has been developed within the jurisdiction. So in jurisdictions where they are so reluctant to look at international decisions or international laws, it would be good to also consider developing the jurisprudence within. But I think what is more important, as in any strategic litigation, is to understand what is it that you want to, what is the problem that you're trying to address. And would the court, whether you're going regionally or national, would the court be receptive to the issue or to the argument that you are trying to advance? Is the judiciary or the forum that you're trying to bring the issue sufficiently progressive and independent? Because if you are going to bring an issue before a tribunal that is not receptive or independent enough, you may not be able to achieve the results that you want. And so it's also an issue of understanding the timing in which, when you can bring what and where. The influence that that particular tribunal is having on a particular country at that particular time will determine whether you go regional, international, or you go local. I'll give you an example. There was a time that we were looking at issues of adolescent sexuality in Malawi, and the fact that the law criminalized adolescent sexuality, where the definition of defilement or statutory rape extended to consensual sex between adolescent children. And then we had brought a case before the High Court challenging the fact that the young boy aged 18 was charged with defilement of a girl of the age of 13 as well. So when we went before the court, the procedure that were taken was a constitutional process, and that required the Chief Justice to certify the case as a constitutional matter. When the case came before the Chief Justice, then the Chief Justice outright dismissed the case as not constituting as constituting a constitutional matter to be determined by a panel of 3 judges. And the court said the matter should proceed, the boy should proceed to be prosecuted for defilement. And then a year later, before the same Chief Justice, when we brought a similar case, different young person, was a boy of 14, defilement of a girl of 15 years of age, the same Chief Justice found that there were constitutional issues that were being raised there. So now when you look at that particular time, Malawi was going through a situation where the termination of pregnancy bill was being debated in Parliament, and there were also arising cases of defilement of children. At that particular point, you could tell that the court was under pressure to bring in a case where we're saying that children shouldn't be criminalized for having sex with children within the same age range. But then later on, the same court had a different view. So it's things like that, that as you plan for strategic litigation as to which forum, when to bring, you need to have a complete assessment in the environment that you're operating in, that is this the right time that we can bring this case, or if we need to wait, or maybe this case will be best dealt with before a regional forum or international forum. But also, you need to consider that if we get a positive judgment, would that be implemented? Because one thing we should know is that litigation is quite expensive, it's time consuming, it's exhausting, and especially more exhausting for the people that are the litigants in the case. Because many times, as lawyers, sometimes we use sorry to use the term use, because that's how it ends up to be in practice, which is not supposed to be, because we are pursuing a greater goal, and then we find individuals that fit in the circumstances that we want to advance. And many times these people are in a very disadvantaged situation where they do not even understand what we are pursuing as in terms of legal issues. I'll give you an example. There was a case that is still in court in Malawi where a girl was raped, and she went to a government clinic to seek for abortion services, and she was denied. And then later on, she was assisted after intervention by civil society organizations, including myself. She was assisted to get a service at a district hospital, which is a government hospital. But then the lawyers that had assisted her initially still went on to file a case, which is still in court, where they're challenging the fact that at the government clinic at the first time, she was denied the service. But you can tell that what this girl really wanted was just to get a service, and she got the service. But then the lawyers also saw an opportunity that this could be a good case to challenge the issue of access to abortion. And then they proceeded. So you find that sometimes you are pursuing an agenda that is not in line with what the client wants, and which also becomes problematic, especially for those that are activists, because not any of those are bad, but we always need to remember our ethics as lawyers to say our duty is to the client. Sometimes you find that you're pursuing something and then the client has changed their mind, or you have taken a different approach. So you need to understand that if you're going to pursue that issue, is it going to be implemented? If you go to a regional court, would that regional decision have any impact, or it would just be there and no action will be taken, as opposed to pursuing it within the jurisdiction? So those are some of the things that we need to consider. But lastly, the one thing I wanted to emphasize is what the doc had also mentioned about network, because in this kind of work, you need to amplify the voices and you can't go solo. So you need to build the networks to make sure that the advocacy is sustained beyond the court process, because a good judgment is not enough. It's only enough when it's actually implemented, and its implementation results into change for those that we're advocating for. So it has to be sustained advocacy, and that can only be done if you have a network that is working together with you. Thank you.
Thank you, Chikondi. Amazing insights. Rizik, do we have anything from your end?
Yes, Gabriel, can you hear me now?
Yes, yes, we can.
Oh, sure. From the judicial perspective, I would say that the most promising legal mechanism that we can embark on is public interest litigation. If the lawyers in Uganda or in East Africa or in West Africa can jointly come together under joint efforts on public interest litigation, then it can be the best mechanism to cap down, to challenge these foreign policies like the global gang rule. That way we can have one, joint voices, and secondly, we can have common cause, and there can be a stronger push that can give us a stronger effect in the end. The other mechanism I would really look at from the legal or from the judiciary perspective is having institutions. I think I recognize Afiana Haki has just launched its institution, faculty to have the right to health advocated through teaching, understanding. After all, you cannot advocate for these rights if you do not know them. So I'm thinking of those two that can really help in to provide promising legal mechanisms for both national, regional, and international level. Thank you very much, Gabriel.
All right. Thank you, my panelists. That was quite insightful. And now we move on to a next one. A little tough, though it's something that is important in this discussion. I would like to ask you, my panelists, balancing oftentimes systemic change with immediate needs is tricky in limited resource settings. So I would like to ask you, how should lawyers navigate this limitation with ethical principles and practicability? I'll start with you, Chikondi, then go to Her Worship, and then Dr. Tom.
Thank you so much, Gabriel. I'm thinking that the limited resources you're making reference to the national pace, or also the impact of the gag rule itself.
Yes.
So yes. So to start with, I think I'll go back to the example that I gave you in terms of limited resources, because as civil society organizations that have also been affected by the gag rule, you find that organizations are fighting for limited resources, and their work is impacted with the fact that they will have to do certain things that they were not supposed to be doing, and they lose their focus on the priorities that they had because that area does not have funding. And then in terms of us as lawyers, even when we take up cases, we are also victims of the circumstances, because some of the litigation that we're involved in is litigation that is instituted by NGOs, and that we align ourselves to the goal that a particular institution is pursuing, to the point that we actually lose our ethics as lawyers. And that brings the point, the example I gave earlier on, that where we are dealing with the case, and maybe the push is that we want to get this done, but then you as a lawyer, you know that ethically you can't proceed to go in such a manner. I think it is important that as lawyers we put ethics first and remember that we owe the duty to our clients and to the court. And in the limited resources that we are working with, if we are dealing with cases, for example, issues of reproductive health rights, as we're talking in this webinar, there are so many players that have done a lot of work, research that we can connect with within the limited resources. Because if we go solo, we'll end up going to court unprepared and not fully representing our clients, because this kind of issues, when it comes to issues of reproductive health, they are very complex. They require, as the doc said, research, and also you bringing a fully prepared case before the court. Because from experience, we have seen that it's only when you've done thorough preparation and you bring everything before the court that the court has no option but to look at what you presented against the law and be able to make a just decision. And then what we have to do is to leverage on those that have done research. And so we need to partner with institutions as we go into this space of limited resources. We need to look at who is working in this area, who has already done research, who can be our ally, who can provide me information so that I fully prepare for a case. Looking at people that have already progressed in certain areas, countries that have already progressed in terms of jurisprudence, learning from those cases, and not also just limiting ourselves as lawyers to just saying I'm going to court with a reproductive health rights case, but looking at how you can make use of the other existing wins that have happened in terms of human rights in general, that you can pursue to also bring in some of the controversial issues that become a challenge. So it's an issue of also being creative as lawyers by using the law itself to be able to advance the things that we are not able to because maybe we do not have adequate resources. But also partnering with some lawyers that have experience, that have worked in the area before, just to tap knowledge from them and how they drafted their pleadings, because some of the challenges that we've seen in terms of cases failing to succeed in court has been how pleadings were drafted, and also the legislation that we relied on, the commencement, even how we commenced the case itself. Maybe the mode we took could have been a different one if we had actually thought through the process itself, which then negatively affects the outcome of the case. So the long and short of it, Gabriel, is that as lawyers, we need to navigate by building alliance, taking advantage what has already succeeded, and not forgetting our ethics as lawyers, no matter the push that is coming from where we are getting funding from, but we should always be ethical in how we represent our clients. Thank you.
Thank you so much, Chikondi. I'll move this conversation to Rizik on your insights on this particular question, then finally, Dr. Tom.
Thank you very much, Gabriel. Ethical considerations in these instances, I would look at instances of running or pushing up for the US policy or the global gang policy vis-a-vis a victim who is in your neighborhood, who is actually challenged with a similar issue before we hear before the policy changes. So I would instead make suggestions that would set up funds to offer legal aid services within our local communities or within our countries. That way, we are not going to wait for the global gang policy to change before we can help the victim who is already subjected to a lot of torture, both psychologically and physical. So I would look at us from where I've been saying this from the beginning, that we provide local solutions immediately as we pursue on how we can change the other policies that are truly affecting us. Uh, the second one would be to set up victim safe space. I know of instances like in my court where someone comes, for example, on an issue of domestic violence, and the accused is in the dock. But after I have remanded on the next hearing date, the victim will come in court and say, Your Honor, I wish to forgive my husband. And when you look critically, she is in company of her mother-in-law or her father-in-law or her brother-in-law. From the onlook, this person has been coerced to come to court and change the statement. So I'm thinking if we found a safe space for the victims instead, within our regions or our countries, there we can see that we are now advocating or practically protecting the victim's rights and practically upholding the right to health. And that way, the ethical conditions can also really come in rather than being jeopardized by the conditions or coerced because you're rated or you're rated to a certain individual or you have nowhere to actually go, but rather to give in to the demands of the people who oppressed you. And thank you very much, Gabriel.
Thank you so much, Your Honor, for those insights. Over to you, Dr. Mulisa.
Yes. Yeah, thank you. Thank you very much, Gabriel. And thank you, my colleagues, for your contribution. I think, if I remember the question, it was about balancing the ethical considerations, balancing ethical considerations and looking also at the financial landscape, how to balance the two. First of all, I think for those lawyers or people who are dealing with public interest litigation, it's quite important to know that one is working for the client. So I mean a good case and a client-centered case, because some lawyers have taken up cases not for the interest of the public interest-related cases, not for the interest of the client and many people, but I think to have a name in court and say people have litigated X, Y, Z or case. So I think we need to understand client-centered interests in such public interest cases while pursuing them. That's quite important. Instead of trying to build a name for yourself as a lawyer or for the NGO doing that. So I think public interest cases also need those ethical parameters. Then we've talked about, even though you're taking up where you have the client involved, or through an affidavit, or let's say 20 women who have had issues of maternal services, there's quite to indulge issues of consent and informed consent, not only consent, in that those involved also understand the rights that are being protected. So it's quite important to look at client-centered issues than NGO or lawyer interests in such a public interest case. Then I usually say that not many public interest cases are expensive. They are quite expensive, and I think it takes an organization and a lawyer to have to be passionate with social justice to take up such cases, because on the road, we recently were working on a case with a pharmaceutical, and as you would know, a case with a pharmaceutical or a major insurance company would need that they might employ some resources to fight back. So then it needs someone who is ready for that case, who knows the purpose, because such big cases, when you're talking about the US and strong and powerful NGOs, then you would expect someone to be bought out or someone to get time and get frustrated and leave the case, because some cases go beyond than 5 and 10 years. So I think it's quite important to utilize. I agree with my colleague Chikondi and Riziki that you need also to, based on what has been established, research from other institutions, research from others, what has done better, and use that also and try to customize it to your own context. But again, it's quite important that ethical principles and prevail in public interest litigation cases. Thank you.
Thank you, Dr. Tom, Chikondi, and Rizik for giving us those very practical ethical considerations that lawyers need to undertake while balancing the systemic change. We are moving on finally to my final question to you, my panel, before I open it up to the audience. Looking ahead now from this conversation that we have had, how do you envision networks like Arila amplifying litigation across Africa, and what support is critical to make reproductive justice a reality? I will start with your worship, Rizik, and then move to you, Dr. Tom, and then Chikondi. Your Honor. Your Honor, if you're trying to speak, you're muted.
No, I'm right here. Thank you very much, Gabriel. From the onset, as we are even right here because of Hafiana Haki, networks really help a lot in amplifying these litigation issues across Africa or across the globe. Specifically, we would think of networking, that a network like Arira would network with another network, maybe in Rwanda or in Malawi, and their voices are amplified. And that way we can have a stronger force to air out our views around the region in Africa or the globe in the whole world. I think to ensure reproductive justice for now, we can you can all agree with me that we are talking about reproductive justice right now, but not all people around the country, like maybe if I'm to use my example in Uganda, are aware of such rights because of the stigmatization that has been associated to some of them. For example, abortion. We are right here understanding that, yes, exceptions are there right from the Constitution of the Republic of Uganda and the national guidelines that the Ministry of Health has issued, where if you have instances of incest or defilement or rape, we can actually allow you to walk in to a public health center where you are recommended to find a qualified doctor to qualify your situation as that of an exception to carry out the abortion, and the operation can kickstart. So right here with these networks, we would say that they're helping quite a lot, one on sensitization, and I would only argue that this should be re-echoed and they partner with other strong networks so that the voice is actually reaching to every individual who is concerned, and that way we can preserve the right to health. And thank you very much, Gabriel.
Thank you, Your Honor, for your wonderful insights. We'll now move to Dr. Tom.
Yes, thank you. I think such networks like the Africa Reproductive Justice Litigation Alliance are quite important while pursuing such regional and global initiatives. I think that first of all, there is need to strengthen the network itself, because the advocates and those doing advocacy in Uganda, in Kenya, in Tanzania, let's say Malawi and Zambia, even the advocates, those who are doing advocacy, should be aware of the legal and policy environment and have knowledge to be able to do advocacy and strengthen their advocacy skills. So I think that while we strengthen the network, it's also quite important that the individual CSOs in the countries are also strong, because the network will depend on the capacity of the individual CSOs in the respective countries. But I think we have had quite good initiatives. I've seen a network of CSOs in Africa submit a case to the African court in the issue regarding children's rights and violation of the African Charter to the African court. So I'm seeing networks doing some strong work. Not only, I've seen networks in environment, I've seen networks in other clusters, and I think also the network for reproductive health in these particular countries should always have joint submissions, joint case strategies. This morning I was attending a meeting, a litigation surgery meeting, whereby lawyers were exchanging information on what is happening to their different countries in terms of litigating contraceptives, the right contraceptives to minors. So how to share the strategies and information in different areas, because what the method that works in one country may not perhaps work in another, but I think learning from each other, strengthening national CSOs to understand and have ability to do the advocacy would be quite important in forming an African alliance. Thank you.
Thank you, Dr. Tom. Finally, Chikondi.
Thank you so much, Gabriel. I think let me agree with the previous speakers in terms of the importance of the network. I think I can't overemphasize that. Also following from the last question that you have put to us about limited resources. And I think having the network is very critical within the limited resources, the impact of the global gag rule, which has taken a lot of funding away from the work towards reproductive justice. So the hope in which we can actually advance and promote the rights of women in as far as reproductive justice is concerned is through the networks that are in existence within Africa. And the good thing is that within Africa, we have enabling a regional legal framework, which is the Maputo Protocol, which we can stand on to advance for rights of women within our respective jurisdictions. And also maybe an emphasis that I would make is within the network, as Dr. Tom has said, as individuals, we also need to be willing to learn from others, because I've seen that in certain strategic litigation where members within the network, within their jurisdiction, they might have funding to advance a certain agenda in respect to reproductive health rights. But then when they look at how other countries have done it, when they pursue it in the manner that they want to pursue it, it may not result in change. If anything, it's going to make things worse. And we have seen activists that have gone forward despite the danger that litigation poses to the community that we serve. They'll still proceed because there's money behind it, or there's an institution that is willing to fund that national litigation. But we should be able to be open to beyond looking at the financing, but also look at the impact that the litigation that we want to do has had in other jurisdictions, and how that has resulted in 10 steps backwards, and then rethink the next steps to take. Because you will see that other jurisdictions have progressed so much that they have had lessons learned through practice. And as we navigate through this hard, difficult area, we need to learn from them to say, how do we avoid the same mistakes that our colleagues made, and learn from what they did best and their failures to effectively actually bring in proper strategic litigation at the right time with the right clients. And I think it's something that maybe we didn't emphasize, but it's really critical in strategic litigation that you get the right client. You can have the right issue with the wrong client at the wrong time. Before a long forum, you get a different result. So as we learn from the network, the members, and what has happened, these are critical issues that we need to focus on and learn how our colleagues have navigated such difficult challenges. Thank you, Gabriel.
Wow, amazing submissions, ladies and gentlemen. These have been my panelists, Miss Rizik Nambuya, her worship, uh, the Honorable Chikondi Chijozi, Dr. Tom Mulisa. This has been quite a lot to unpack. It's been amazing. And now I would like to open it up to you, my audience. It's time for your voices. I know you have some brilliant questions that you probably have. I see we are pressed for time. It's 4 minutes to the hour of 4, and by 4 p.m., we anticipate to be out of here. So if you have any questions, please, I once again encourage you to drop them in the chat room, or you can raise your hand and ask that question. I will give only room for one question because we are quite pressed for time. I see there are a lot of comments coming in the chat room saying that the session has been wonderful. Thanks be to you, our panelists. People are acknowledging the wealth of information that you have shared, and so I think moving on now that it seems we are all in tandem with the discussion, I would like to now move to uh, 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 the close of our session. It's been quite an incredible session for us. It's been insightful. We have learned a lot, and in particular, we have explored how US policies like the global gag rule disrupt reproductive justice. And there has been a very good spotlight on litigation successes from Malawi, Uganda, and Rwanda. And we've also mapped out some strategies from grassroots partnerships to regional courts to fight back at this global gag rule. And I thank my panelists, Chikondi, Rizik, and Tom, for your insights that have lit a fire in our bellies. I know right now as we speak, we are not the same. I probably deserve to take a bottle of water later on to quench this fire. But to you, our audience, it's been an amazing journey. It's only a beginning. Please expect a recording of this to be shared with you, and we'll be interacting more in future days to come relating to training sessions along this subject of reproductive health rights. Like I said earlier, our session is co-hosted this afternoon by Afia Nahaki, and I have my very good friend, Mr. Aksam Nsubuga Musajawa Kabaka. Please come and give us closing remarks, and then I'll make a few announcements thereafter. Aksam.
Thank you so much, Gabriel. I don't know whether you can see me. However, my network is not so good. So you will please allow me to stop my video. But it's a pleasure to be on, and just want to thank you so much for putting this out. On behalf of Afia Nahaki, I just want to thank all the panelists and the litigants that are on this call. I just have three things to put out is that today's conversation has broadened our perspective, shifting from a national focus to a regional approach. And I just want to re-emphasize that the need for regional solutions is the only thing that we can continue to leverage on. Three things maybe is that the need for regional legal strategies in advancing reproductive justice is urgently needed. As we've all heard from our panelists, is that the efforts are there to advance reproductive justice, but these are narrowly or we are aware of the fact that they are already in motion, but a lasting change requires engaging the regional legal mechanisms, and we must strategically push for policy shifts through these treaty bodies and regional courts. So we need to ensure that there are stronger legal protections for reproductive rights. And I just want to urge all the litigants or the members on this call that we should leverage the East African Court of Justice, because it's one of those regional avenues that we have in place. And additionally, the progressive judicial decisions. We've all heard from our panelists that there have been good precedents from across the region. Case in point is those from Malawi, where our panelists, that is the Honorable Chikondi, mentioned precedents from the Lesotho. We heard from Uganda, and of course, Dr. Tom mentioning those in Rwanda, not forgetting the progressive decisions that our team at SEHAD have led. So we need to go beyond that, and we are hopeful that these powerful vehicles of justice can foster a change. Secondly is the strengthening the legal advocacy through the collaborations. Dr. Tom mentioned that litigation alone cannot be leveraged or utilized as a standalone, but we should also use the other mechanisms. So with this, we have the civil society organizations that are central to advancing reproductive justice. But of course, their work in advocacy, legal aid, and the policy reforms or pushing for those policies has created a voice. But then the vital role in pushing all this is that we should have a concerted effort for all of us to come on board and push for these reforms within an alliance. Later on, I'll speak about that, but going back to the topic that the global gag rule or the Mexico City policy and how it continues to threaten reproductive health programs, restrictions to funding, abortion rights and services. All these undermine reproductive rights and limit access to critical health services, especially in developing countries like Uganda, and of course the other countries within the region. So understanding these restrictive policies and their impact enables us to develop targeted legal strategies and counter these effects. Second, the third is building alliances. Dr. Toms later on talked about the AGLA, that is the African Reproductive Justice Litigation Alliance. This is an alliance that was started or established by Afia Haki, and it has laid ground or a platform for legal practitioners, civil society organizations, activists to come together and collaborate, share expertise, but also challenge restrictive reproductive health policies, both at national level and regional level in the different regions, that is SADC, ECOWAS, East Africa, and East African, among others. So we urge all of you to please come on board and join this alliance. I'm sharing a link to this alliance in the chat room. So please check the platform check the chat room so that you can be able to join this alliance. Sorry, Gabriel, I'm about to finish in a few minutes. The other last thing is about the collective impact. I would relate this to building alliances that Tafya na Haki, through our program, that is the Litigating Reproductive Justice in Africa program, we are committed to strengthening these efforts. And in addition to the role of the alliance, we are strategic, and we've supported a number of cases that is to do with the public interest litigation cases, but also actively investing in capacity building initiatives. For instance, the short courses that we usually conduct. And I'm happy to have Dr. Tom. Dr. Tom is one of our participants of one of the cohorts of the short course. So I believe that these have benefited strongly to many stakeholders and those passionate about advancing reproductive justice in Africa. But also looking at the trend, that is the global gag rule and its effects, is something that we have actually prioritized. We have the mentorship program, we have the short courses that are specifically targeted to the global gag rule or the Mexico City policy. And we are sure that through these efforts, the collective impact and the alliances and the collaborations that we are building, we will strengthen and advance reproductive justice. So I want to encourage all of us to not stop at this, whichever way you can, that is, if it is advocacy, if it is litigation, but broadly today's discussion goes to litigation efforts. And as I end this, my sincere gratitude goes to the East African Law Society for fostering these regional collaborations among litigants, bringing on board persons from all over the region and from the different law society bodies or the legal profession bodies is something that we can't take for granted. And such platforms are essential for knowledge exchange and, of course, they coordinate advocacy at a regional level. So thank you so much, Gabriel, and the team at the East African Law Society Institute. So my final call is to urge us all to remain steadfast in leveraging the regional avenues, because I believe some of our national avenues are restrictive in a way. But I believe that since these regional avenues, that like the AU, like the East African Court of Justice, among others, can be leveraged to push forward and advance reproductive justice. And this requires a lot of amplification, like a lot of African voices to push for these progressive policies. So I want to thank all of you for being a part of today's session. And thank you so much to our panelists, our moderator, and everyone that has been on the call. Asante sana, and see you again. Over to you, Gabriel.
Thank you, Aksam, and the team from Afya Nahaki. Send our sincere regards from ELS to Dr. Mulumba and the entire management at Afya Nahaki. Now, ladies and gentlemen, as we bring this powerful session to a close, I want to re-echo what my brother Aksam has said and extend my sincere gratitude to you, our very phenomenal panelists, Chikondi, Rizik, and Dr. Tom. You have done an exceptional job. Your expertise, your passion, and commitment to justice have illuminated not just challenges, but pathways forward in the fight of reproductive rights. You are not just legal minds, you're architects of change, and we honor your work. To you, our audience that engaged in this discussion, thank you for your continued support and participation. I know we are building a critical mass, we're building a movement, and I know the insights that have been shared here today will not just stay in this space, but will be sparked in the courtrooms. I look forward to hearing a report from Her Worship Rizik from this particular session we've had, that there's been change in the courtroom when it comes to litigation of reproductive rights in communities. We need to see change. And who better to be a pillar of change than you, our participants this afternoon? We'll be sharing a recording of this session with you, and we are working on modalities of sending you certificates of attendance, and to you, our panelists, certificate of appreciation. And as we sign off this afternoon, I would like to also welcome you to the month of April. The month of April at the East Africa Law Society promises to be very, very amazing. We have exciting sessions lined up for you. On the 6th of April, ladies and gentlemen, we'll be rather on the 8th of April, we'll be having a discussion by legal titans across the region, and they'll be telling us their story, how they saw it. And it's titled Through the Eyes of Legal Titans. We'll be navigating the evolution of legal practice, insights, challenges, and strategies for success. So we have a panel of people who have been practicing for long, over 30 years. They'll tell you how they saw practice evolve from the point at which they joined it until now, and how you can succeed in your practice. Our next session will be held on the 10th of April, that is next week, and we'll be discussing AI ethics and the rule of law, and we'll be navigating business and human rights in the digital age. You don't want to miss these sessions coming up next week. So I would like to thank you once again for tuning in this afternoon. Indeed, it's been quite amazing. And let's continue litigating, let's continue collaborating, and let's continue pushing for a future where reproductive justice is a reality for all. Asante sana, and have yourselves a very lovely afternoon. And yeah, we are together in this fight for justice. Thank you, and goodbye.